Hi everyone, welcome back to this channel. So today we are going to discuss about the development of trade union laws in India. The Labour Commission, seeing the agitation and active protest from early trade unionists, the then British government appointed commission, namely the first one, the Bombay Factories Commission of 1884, the Indian Factory Labour Commission 1840, the Royal Commission on Labour 1902, the Indian Factory Labour Commission 1908, etc. In 1911, the first Factories Act, which was enacted in 1881, was amended to provide for restricting the working hours to 12 for adults and 6 for children. Now, in B.B. Wadia case, that is also known as Buckingham case, B.B. Wadia's case or Buckingham case 1920. Buckingham and Carnatic Mills, popularly known as Binney and Company, were owned by the Englishmen. The factories situated in Madras and other cities, B.P. Wadia and others of that company formed a trade union under the banner of Madras Labour Union. He, along with his 9 associates, resorted to strike in furtherance of their demand in 1920. As a result, the management dismissed about 50 workers, including the leaders. The workers started strike and the management announced lockout. Moreover, the management filed the suit in Madras High Court against B.P. Wadia and others, claiming damages for the period of non-working, that is estimated loss of 75,000 rupees, and also filed a case for inciting the workers to commit the breach of their contract of service. Further, they also sued the leaders for criminal conspiracy. Basing on the judgment given by the English court in Tuffield Railways Company case, in which the court awarded a compensation of £23,000 to be paid by the trade union to the employer, the Madras High Court admitted the contention of the company and gave judgment in favour of it. B.P. Wadia failed to pay such huge amount. He was to be sent behind the bars. On pressure from many sides, the management agreed to withdraw the case on condition that B.P. Wadia and his associates not only leave Madras city but should also give up the trade union activities. Consequently, they left Madras city. Now, enactment of Trade Union Act 1926. So the Buckingham case was on 1920 and enactment of Trade Union Act 1926. The trade union movement shifted to and concentrated upon demanding the legislation recognizing trade union as legal entities. A private trade union bill was moved by N.M. Joshi in the Central Legislative Assembly in 1920. He withdrew the bill on the assurance that the government itself would submit the bill. Consequently, in 1925, the government submitted the Trade Union Bill, which was passed as Indian Trade Unions Act 1926, which gave status and immunity to trade unions. The Act of 1926 provided protection against criminal conspiracy, civil liability, and against tortious acts. The Trade Disputes Act 1929 made the strikes and lockouts in public utility service without due notice illegal and punishable. The main objects of this act is to provide a conciliation machinery to bring out peaceful settlement of industrial disputes. Workmen's Compensation Act 1923 provided for the social security to the workers in the form of compensation to be paid by the employers to the workers who suffered injuries out of and in the course of employment. Enactment of labor legislations to protect interests of the workers was another factor that gave impetus to the trade union movement in India in the post First World War period. Now, the list of amending acts and adaptation orders relating to Trade Union Act 1926 are the Indian Trade Unions Amendment Act of 1928, so as to provide for the procedure of appeal against the decision of the registrar. And the second one, the Government of India Adaptation of Indian Laws Order 1937. The third, the Repealing and Amending Act 1942. The fourth one, the Indian Independence Adaptation of Central Acts and Ordinance Order 1948. Now, fifth one, the Adaptation of Law Orders 1950. And then we have the Part B States Law Act 1951. The Indian Trade Union Amendment Act 1960, which made some changes in Section 2 Subclause F, 3, 4, 6, 14, 16, and 28 of the Act. The Indian Trade Union Amendment Act of 1964, in which the word Indian has been deleted and became Trade Union Act. Now we have the Central Labor Laws Extension to Jammu and Kashmir Act of 1970, the Trade Unions Amendment Act of 2001. Now, with respect to objects and reasons of the Trade Unions Act 1926, the object of the Trade Union Act 1926 is to provide for the registration of trade union. The Act also aims at defining the law relating to the registered trade unions in certain respects. The law defined in the Act only relates to the registered trade unions, and the unregistered trade unions cannot claim any benefit or protection under the Trade Unions Act of 1926. The Trade Unions Act 1926 had two objects. Its first object was to relieve all trade unions from some of the civil and criminal liabilities, that is, to grant them immunities from civil and criminal liability. The second object was to provide a system of voluntary registration for trade unions, requiring the adoption of adequate rules, the keeping and audit of proper accounts, and filing of annual returns. In order to encourage registration, a legal status was given to the registered trade unions, conferring certain powers and advantages not accorded to the unregistered unions. Now, scope or main features of Trade Unions Act 1926. The first one, the registration of trade unions. The Act makes provision for registration to trade unions. He is appointed by the registrar is appointed by the appropriate government. He registers the trade union. Now, second one, rules to be made by the trade union. This Act mentions the rules to be made by the trade unions relating to the objects for which the union has been established, admission of members, and the maintenance of the list of members, etc. The third, constitution of general fund and political fund. The unions can provide funds separately for the general fund and political fund and can use these funds for the objects mentioned in the Act. The fourth one is immunity to registered trade union. The Act provides immunity from civil and criminal suits to be registered to the registered trade unions in respect of any agreement made for the purpose of any object specified under the Act. Now, the fifth one, amalgamation of registered trade union. The Act provides for the amalgamation of two or more registered trade union to become one without dissolution. The sixth is the dissolution of the registered trade union. A registered trade union may also be dissolved according to the provisions of the Trade Union Act 1926. The seventh one is submission of returns. A trade union should submit the returns as mentioned in the Trade Unions Act 1926. The eighth one is the regulation. The appropriate government may make regulations for the purpose of carrying into effect the provisions of the Act 1926. And the ninth one is the penalties and procedure. The Act fixes the penalties for a particular failure noted in the Act and for supplying false information regarding trade unions. So the main features or the scope of Trade Union Act 1926 are: 1. Registration of trade unions. 2. Rules to be made by the trade unions. 3. Constitution of general fund and political fund. 4. Immunity to registered trade union. 5. Amalgamation of registered trade union. 6. Dissolution of the registered trade unions. 7. Submission of returns. 8. Regulation. 9th, penalties and procedure. So that is a brief intro towards Trade Union Act 1926 and how it came into being. Thank you for listening. Like, comment and subscribe. Please click the bell icon so that you get a notification when I upload my next podcast or a video. Thank you for listening. Have a nice day. Take care.